Hello everyone, I am Sakshi Sharma from Lawminds, here presenting you video about an interesting topic, that is economic interpretation of law. So let's start the topic, and this could be read as under 5 categories, that are introduction, then meaning, then the other part deals with the relations of other laws with economic interpretation of law. Then we go through the key principles of the economic interpretation of law, and in the last we study about conclusion and the other aspects of the economic interpretation of law and what concludes it. Let's start with the introduction. Economic interpretation of law relates to the economic analysis of law of jurisprudence, and assumptions regarding may be based on intuitions and moral beliefs, scientific data, legal rules, and legal perspective view. The rationale behind the economic interpretation of law is rather simple: to implement economics to the legal decision making process, and it has a great impact on economic interpretation of law. Now let's study about the meaning of economic interpretation of law. The economic interpretation of law means perspective in legal theory that examines the relationship between legal rules, institutions and economic outcomes. कानून की आर्थिक व्याख्या का अर्थ है कि कानूनी नियम संस्थानों और आर्थिक परिणामों के बीच के संबंधों के दृष्टिकोण को बताता है कि कैसे हम इसे देख सकते हैं और समझ सकते हैं, और ये कानूनी प्रणाली समाज कल्याण और आर्थिक व्यवहार को कैसे प्रभावित करती है. It seeks to understand how laws and legal institution functions, develop and influence society by focusing on economic incentives, efficiency and outcomes, and also mentions about that the individuals are rational decision makers who act in their self-interests. Let's come to the next category, in which we'll study about the relation of economic interpretation of law with jurisprudence. Jurisprudence is the study of the nature, sources and principle of law, whereas economic interpretation of law is related to realist jurisprudence, which generally examines the nature of human behavior and social outcomes. Economics being a science of money and wealth, and jurisprudence a science of law, both are intimately correlated. It is a method of legal analysis and legal perception that applies economic concepts and reasoning to legal issues. Economic interpretation of jurisprudence is an approach that applies economic principles and analysis to the study of law, and this can be explained in some key points that were: first of all, enacted or imperative element. A developed body of laws has two elements. One is an enacted or imperative element, which is the modern element of law. Usages and customs, the rules that permit proofs of the usages and customs of a particular trade or business to be given in evidence to aid in the interpretation of contracts, can be resolving using economic principles. Law and economic movement. This movement offers a general theory of law as well as conceptual tools for the analysis of legal issues. Even rules of evidence and legal ethics have proved amenable to economic analysis. Descriptive analysis. An economic explanation of law may not do justice to everyday legal conceptions. However, it could be argued that law should adopt economic efficiency as the central aim guiding judicial decision making. Economics in law. Understanding the significance and the limitations of the economic analysis of law, and it is important to understand the relationship between economics and jurisprudence. And the last, Marxist philosophy. This philosophy signifies that legal relations are determined by the economic base of particular kinds of society and modes of production. To examine the relation between economic interpretation of law and jurisprudence. Now let's start with the study about the principles of the economic interpretation of law. The economic interpretation of law is just mere approaches of legal theory and its impact on society. Here are some key points regarding the principles of economic interpretation of law, which are as listed as: first, rational choice theory. This theory assumes that individuals and entities act rationally to maximize their own self-interest, subject to constant incentives present in their environment, and seeking to optimize their benefits, minimize their costs. Second, efficient legal system. Economists often analyze the efficiency of legal rules and institutions by examining whether they achieve optimal outcomes, where the benefits of a particular legal rule outweigh its costs, and allocate resources to resolve conflicts in a manner that maximizes overall social welfare. Third, incentives and deterrence. The economic interpretation of law considers how legal rules and sanctions influence the behavior of individuals and organizations, and it provides the use of legal penalties and rewards to deter undesirable conduct and encourage compliance with the law. Fourth, property rights. Property rights provide individuals with incentives to invest, innovate, and use resources efficiently. Fifth, transaction costs. Legal rules and institutions can influence transaction costs, which include the expenses incurred in making economic exchanges. Sixth, law and economic of contracts. The study of contract law through an economic lens focuses on the role of contracts in facilitating voluntary exchanges and enforcing promises, and it examines how legal rules shape contractual arrangements and mitigate risks for parties involved. Seventh, tort law and liability. Economic analysis of tort law involves examining how liability rules and the assignment of responsibility for harms influence behavior and help internalize external costs to prevent inefficiencies. Eighth, competition and antitrust law. Economists explore the role of a competition in markets and analyze how antitrust laws regulate monopolistic behavior to promote competition and consumer welfare. At last, concluding the topic that we covered in the presentation provides the economic interpretation of law argue that it may oversimplify complex social and moral issues by reducing them to economic considerations. The perspective view of economic interpretation has been influential in various fields such as contract law, tort law, property law, and corporate law, among others. It has also influenced policy discussions and lawmaking by providing insights into the potential economic consequences of legal rules and reforms. Overall, the economic interpretation of law offers valuable insights into how legal systems interact with economic forces and can provide a framework for analyzing legal rules and institutions in terms of their impact on society and the economy. कुल मिलाकर कानून की आर्थिक व्याख्या इस बारे में बताती है कि तार्किक प्रणालियाँ और आर्थिक ताकतों के साथ कैसे बातचीत करती है, समाज और अर्थव्यवस्था पर उनके प्रभाव के संदर्भ में कानूनी नियमों और संस्थानों का विश्लेषण करने के लिए कैसे एक रूपरेखा प्रदान करती है. This also allocates with the study of various legal theories of jurisprudence and schools of thought of natural law theory and legal studies. Here I end the video and thank you all for watching the video. Hope this presentation gives you valuable information about economic interpretation of law. Please like, share and subscribe. Thank you so much.